So, welcome to another video series where I'm going over each part of the bankruptcy petition. Now, today, as you can see, I'm going to be focusing on cold debtors. I have here on the YouTube channel all the different parts of the petition I've done. I do them in order as they're available on the court website. But if you want to read it or there's other information that you need, you can always go to my website, bankruptcy.blog, where you it doesn't matter if you're looking at an individual post or you just on the main page, just scroll all the way down to the bottom. On the left-hand side, you'll see a link that says how to file for bankruptcy, and you'll see all the different parts that I've covered there. Now, I'm going to focus on, and I've been saying this from the beginning, I don't go over the actual form filling because this is just, common sense. Who's your cold debtor? You put that information there. So it's the same thing for other parts where, which debt do you have? Just put down the debt. What I focus on is issues that you're not going to find probably in other blogs or in other videos. It's definitely not going to be in any of the forms that you use. And you can't call the clerk's office because they can't give you information. So the stuff that I'm going over is just information. I've been doing this for a long time, 26 years now. And a lot of this information you're probably not going to come across on a search. So even when I wrote my bankruptcy law textbook for paralegals, I go over a lot of issues because I think that's the important part, to be able to recognize an issue before it happens, because once it happens, once you file it, it's probably too late. Okay, so let's start off with cold debtors. Cold debtors, simply enough, get whatever scenario you want. It doesn't matter if it's a spouse, a domestic partnership, friends, neighbors, cousins. I don't care. It's the other person who's going to be listed on that debt. And the first thing you need to realize is if you file for bankruptcy and you have a cold debtor, the cold debtor is now responsible for the debt. Now, if you're married, sometimes I ask clients, are you sure you don't want to both of you file for bankruptcy? Because the problem is, if it's at some point you realize the other spouse should file for bankruptcy, guess what? Now you're paying a lawyer to file two separate bankruptcies, which is going to be a lot more expensive than just one bankruptcy where both spouses are included, and get rid of that issue. So keep that in mind if you're getting ready to file for bankruptcy and you're meeting with lawyers and you have this issue of whether, your spouse should be included. Now's the time to make that decision. And of course, find out the pricing from the lawyer. Like I said, why pay for two cases when you can get it knocked out in one? Okay. Now, if let's suppose a scenario where the co-debtor is an ex-spouse, right? And that happens, you got divorced and you couldn't refinance, whether it's a mortgage or a car loan, whatever it is, you couldn't refinance it. So one person is on that loan. Now, I know the marital settlement agreement and the court order that approved it says at some point there's a liability clause saying, well, the other spouse is held harmless from liability regarding these debts. And maybe you list, multiple debts, or it's just one. The problem is, if you file for bankruptcy, that goes out the door because family court is state court and bankruptcy is federal court. Uh, Federal court's above state court. The other issue is hold harmless means they're not going to be held liable, but that's not necessarily true. And the reason is very simple. When you both applied for that debt, you signed a contract with that lender saying, we're going to pay for the car, we're going to pay for the mortgage, etc. A judge in state court is not going to be able to come in and undo that contract. They just can't. They don't have the authority, the legal authority to do so. So a lot of times people say, why are they coming after me? It says on my divorce documents that I'm not liable for this debt. Well, you're listed on the debt. So what does that hold harmless clause really mean? Well, suppose there is no bankruptcy and suppose the person has a car repossessed as an example. And now the creditors come after you and they say, well, you're on that debt and you owe $10,000. And the other person hasn't filed for bankruptcy. You can sue that other person and say, this $10,000 is not my problem. But when bankruptcy is involved, unfortunately, that's it. The state court, family court is going to lose jurisdiction. And at that point, the cold debtor who did not file for bankruptcy will have to pay that debt. Now, the other issue is, especially if it's with spouses, they can, if they can afford it, then keep the car because at least one spouse will be able to maintain good credit. We always need to have good credit one way or another. Is something we can't avoid. So even though one spouse wiped out that debt, the other spouse can continue making payments. So there's not going to be any issues there. Okay. Now, make sure that you always list a debtor. It doesn't matter that it's your spouse or not. Just make sure that to list your co-debtor there. And part of that is because of the automatic stay. Remember the automatic stay, and let me see if I can type that up in here, and I'll put links to that. Remember, the automatic stay happens automatically when bankruptcy is filed. So it means if there's a collection lawsuit pending and then you file for bankruptcy, the collection lawsuit has to stop. They cannot move forward until it is determined what happened with bankruptcy. But when you include your co-debtor, guess what? They are also protected by the bankruptcy. This applies whether it's Chapter 7 or Chapter 13. Chapter 13, it could last 3 or 5 years, that protection. If it's Chapter 7, only a few months before you get the process of the discharge, but that also allows people to try to figure out what they're going to do. Are they also going to file for bankruptcy? If they're not spouses, maybe they're a relative or a family member, mom or dad, maybe signed off on that loan, or work out a payment plan. And of course, they could always take back the vehicle because now the vehicle's in their name. So those are some of the issues you're going to have to face if you're dealing with co-debtors. And remember, when we're dealing with these co-debtors, the only real way, and I've discussed that multiple times in videos and blogs, is to be removed of all liability is if the other person refinances solely in their name. This goes back to a video I posted recently regarding divorces and quitclaim deeds, where I say the quitclaim deed doesn't absolve you of liability on the mortgage. If you're on the mortgage, the quitclaim deed, all that is doing is transferring the interest in the property to the other party. It doesn't transfer the liability. And so the problem with that with mortgages, it's clear. Mortgage lasts forever, right? 3 decades we can have this mortgage lying around. So imagine you get divorced 5 years into a mortgage for the next 25 years. Any late payments, anything could happen that could ultimately affect your credit, maybe force you to file for bankruptcy. Maybe your assets are not protected. It's even going to make it more difficult for you to qualify for other loans because you have this debt in your name. And so the banks might say, we're not going to have a second mortgage now in your name because it's just the numbers don't add up. The income is not there. So keep that in mind. It's important to list a co-debtor because it will protect them as well with any lawsuits. Okay. Any other questions regarding this? I've seen some of you have posted questions in the past, and I think I've pretty much replied to everybody regarding steps in the petition. But as always, any questions, feel free to post them in the comment section. Okay. Thank you. Best of luck, and I hope you're enjoying the video.